right, welcome everyone. My name is Christine Haker. For those I didn't get a chance to meet, but I am the Dayton office of Thompson Hine Partner in Charge. And thank you for coming today. What an incredible breakfast spread. Sorry for everyone listening remotely, but there's a lot of great food and company here. So Roger, my partner here, has a great program along with his colleagues for everyone today. We appreciate you being here, whether in person or virtually, and we hope you have a great day. And obviously, the Dayton office of Thompson Hine is here for whatever you might need today. Roger?
Thank you. Thank you, Christine. And thank you, everyone, for being here and joining us virtually. Again, my name is Roger Bora. I'm one of the speakers today, partner here at Thompson Hine. And before we kick off, we need to do a little housekeeping. We have 2.5 hours of CLE and CPE credit pending for today's program. For those seeking credit and attending in person, please be sure to sign the sign-in sheet and document your time and your name and your bar number or your professional number. For those seeking credit online virtually, you will find your accreditation forms attached in the handout section of the GoToWebinar user panel on the right side of your screen. You should download these forms and record the appropriate codes to receive credit. Following CLE and NASBA guidelines, we will announce 3 codes every segment for a total of 9 codes. They will be announced throughout the presentation and we'll repeat them at the end. If you have any issues accessing any of the handouts or documents online, don't worry. We'll email the slides, handouts, and the CLE CPE documents following today's program. And to proactively address a question we frequently receive, today's webinar is being recorded and we will send a link to all the registrants within 2 to 3 business days. For questions for virtual attendees during today's presentation, please feel free to use the question box on the user panel at the right-hand corner of your screen. We will answer questions as time permits. We will answer a question or two in between or after each segment. Feel free to reach out to any of us, any of the speakers directly if we don't get to all of the questions today. I will now turn the program over to Debbie Durr, an international trade specialist with the U.S. Commercial Service in Cincinnati and the U.S. Department of Commerce. Debbie, take it away.
Thank you so much, Roger. I also appreciate all the work that went into putting this together, coordinating this, the staff at Thompson Hine, and hosting this. It's a beautiful room for those of you that aren't here, and we appreciate all the virtual attendance too, we really do. And I want to thank Natalia Magnuson for her collaboration and Clark Schaefer-Hackett for partnering today. My goal is to make sure that if you are a small business here attending this program today, when you leave, you will have an idea of the resources through the federal government available to you to increase your foreign business, your export sales. But also, if there are service providers attending today and you're in touch with small and medium-sized business, I would hope that you also would have an idea of what can be done for them through the federal government, maybe pass that along. We would love to be in touch with even more businesses to help them increase their export sales. As Roger said, I am with the Cincinnati office, and we have 3 offices in Ohio. I report to Cincinnati, but I service the greater Dayton region, and I actually have a satellite office at Wright State University here in Dayton. So government is huge and kind of confusing to the public. I like to identify exactly who we are. I've been introduced to people as being with the U.S. Chamber of Commerce, the local Chamber of Commerce, State Department of Commerce. I am with the U.S., the Federal Department of Commerce, and commerce is vast. It includes National Oceanic and Atmospheric Administration, the people who fly through hurricanes and airplanes, the U.S. Census Bureau, and then under Commerce is the International Trade Administration, or ITA, and that's made up of 3 divisions, one of them being enforcement and compliance, Those are the people who go to bat for U.S. industry to level the playing field if there are unfair trade practices. They also manage the foreign trade zones. And then the other division we work with closely is industry and analysis, and they do exactly what it sounds like. They specialize in specific industries. Work closely with industry associations to track industry trends worldwide and help with input on U.S. trade policy. And they also work with a grant program that we award certain industry groups or regional groups that want to help a group, a membership, increase their export sales, called the Market Development Cooperator Program. And then our agency, our division, is the U.S. and Foreign Commercial Service. That's our legal name, but we go by the CS, or Commercial Service. And our agency is comprised of about 1,600 employees worldwide, with 100 offices in the U.S. of people like me. Each of those offices services a geographic territory. And our job is to reach as many U.S. businesses as possible that might need assistance with increasing their export sales, and actually work with them on any challenges in the entire export process. And I'll get into more of that later. We're able to help these companies get into foreign markets and because we work with the U.S. embassies and consulates worldwide. The Commercial Service has about 150 offices in 80 countries. And in those offices, we hire foreign nationals, and then we assign them a portfolio of industries, and they are managed by commercial officers. These are U.S. citizens that serve in the Foreign Service. And these colleagues, these foreign colleagues, are invaluable to us because they're in touch with the players in a market, the industry groups, trade shows for specific industries, and they're just incredible. For example, I have a call tonight at 8 p.m. with China to talk to a U.S. business at that time about their potential in the China market. And so that's how we're able to do what we do through these folks. And then we have a partnership with U.S. State Department where we can provide services in another 65 countries. So I mentioned small and medium-sized business because that is our core mission. Those are the companies with a lot of growth potential. Large companies have an army of people to do what we do. So we want to focus on those small companies, and those are small by SBA standards. So we're talking companies with fewer than 1,000 employees, but most of the companies I work with are 6 employees, 10, 100, vary in size, but they're usually much smaller. We want to give them any and all market intelligence they need to make those decisions about going into a market or determining the potential, and we want to increase U.S. jobs by doing that. We have a variety of products and services to help them assess those markets and find qualified business partners. So those could be end users, agents, or distributors. And I think it's still important to use the leverage of the U.S. government to open doors. I do believe that foreign businesses are still very welcoming when a U.S. embassy calls them and says, hey, we'd like to introduce you to this U.S. company or tell you about these U.S. supplies. It's still very important, I think, in a lot of markets. So when we talk about the entire export process, it's the whole ball of wax. And the most important aspect, of course, is getting paid. And we work with partners to help U.S. companies with terms of payment. Compliance with U.S. export laws is very important. We have some of the strictest, if not the strictest, export laws in the world. And my job is to make sure that the companies we're working with stay out of trouble. Also help them comply with foreign standards and any foreign laws. And now that COVID is over, well, I would say for the most part, and we can be in person. It was very important to me always to be in person with a company, to be able to have eye contact and get to know the salespeople, the management, the accounting people. to help them coordinate how this is being done throughout the company. Many times companies internally don't communicate. And so the salesperson is out promising the moon, which nothing against salespeople, that's what they do. But they a lot of times may not be communicating with the traffic manager that needs a document at the last moment, you know, when something has to get out the door. And so it's really important that everybody understand what's going on. We're also instrumental in finding the right customers. Through a lot of research and discussion with our companies, we want to make sure we're finding the right contacts for them. And beyond that, we can provide a lot of information about those contacts. And it really depends on how much the US company wants to know, but we can give them a lot of information about those potential partners. And then another thing that we've gotten into more in the last couple of years is a company's web presence and how they market on the web. We want to look at their website and see what that looks like to foreign potential customers and partners. For example, if you have a website as a small business and you know, it's been created according to your budget, you may have like a form on there that a foreign company should fill out to contact you. If they're in the Middle East and the way they write is different, it may be a problem for them. So just things like that we want to look at. And then shipping and logistics, I get a lot of questions about that most of the time. Problematic situations where a small business may not be familiar with the entire export process. Here's an example. A machinery company that makes customized machines sold to China. And this Chinese company then needed a certain part refurbished and wanted to send those back. Well, the US company only sells Ex Works. That means that they just get it ready and the foreign company picks it up and they're done with it. They don't get involved in the logistics beyond that. So I had to help this company figure out what Incoterm they should quote to the Chinese company, because the Chinese company asked them to get it to the Dayton airport once they were done with repair and refurbishing. Well, that's a different Incoterm, and that's a different set of responsibilities on the part of the exporter. So those kind of issues I get involved with, helping real nitty-gritty issues.
Yeah, I guess this is session 1, code 1. As we mentioned, there'll be 3 codes per session. So please jot this number down if you are seeking professional credit.
So we really get into the details with standards and regulations in foreign markets, documentary requirements and labeling for customs clearance in another market. For example, I have a company right now that sells a piece of equipment that comes in contact with food products. And because of that, it's being sold to the UK, but the UK customer then is selling that to Spain. So we have kind of 2 layers of directives for safety for products that come in contact with food, one being the European Union's directives, but then the Spanish government has its own food safety agency. And so the company, we're helping them through my contacts at the European Union, US mission to the European Union. We have an office in Brussels for EU directives. I'm working with them as well as Spanish colleagues, but also USDA, Foreign Agricultural Service, are helping me with what's the responsibility of the US company with meeting those requirements. What's the responsibility of their UK customers, since they're actually the ones that are selling to Spain. So we get involved with that. Another issue I'll mention was this last year, the government of Egypt put in place a new customs clearance system called NAFISA, which required US exporters and all exporters that are selling to Egypt, they had to sign up in this system, which is pretty similar to something like ACE Customs uses in the US, to screen any imports for safety, for security. And they launched it so quickly that this caused a lot of consternation on the part of a lot of US exporters who were contacting us and saying they weren't sure what their risk was in putting documents into the system and their information. And so I contacted our office in Cairo and found out they had actually, along with a lot of other businesses in Egypt, petitioned the Egyptian government to delay the launch of this system for about 6 months until it was more transparent and everyone understood how it would be used and how it would affect them. And that's exactly what happened. So I think that we're very helpful in those kind of instances. Rules of origin, we have about 18 trade agreements with 18 countries, US free trade agreements now. And my job is to make sure companies understand how to use those to benefit their customers so they sell more and everybody's happy. We do provide background reports on foreign firms. And we have a service where we will review your company's website to provide you with analytics so that you can go on and use a third party then with the analytics that we've provided. This is just an example of algebraic formula in one of the rules of origin in one of the US free trade agreements. So you have to be able to get in there with the accounting department per unit and look at this. So the US company can determine whether they qualify. I will say that we require that US companies working with us have at least 51% US content if it's a product. We work with services and technology also. But interestingly enough, in some of these newer free trade agreements, you may only need 35% US origin to qualify. So it just depends. I just want to say that the small and medium-sized companies I mentioned earlier are extremely important, we all know, to the US economy. And most of the US exports are made by smaller companies because they're here. The large multinational corporations are making it elsewhere many times. But interestingly enough, the number of US companies in this group are maybe only the majority of them are only selling to 1 or 2 markets. And so we want to increase that. We want them to sell to more than 1 or 2 markets if they have that potential. So I think a lot of us are familiar with how the last 2.5 years changed trade, port stoppages, severe supply disruptions, which we're still hearing about, obviously, reshoring. A lot of companies that were manufacturing maybe in China or other markets decided to bring their manufacturing back to the US or maybe leave China and go into Southeast Asian markets for manufacturing. In fact, there's an excellent article this morning on reshoring in the New York Times business section about a small business, and then they also talk about some other ones. But this small business was having a heart attack watching radar blips of their goods sitting in ports and ships and unable to get their goods during COVID. And the guy did a lot of research, and after a few years, he's now bought a former furniture store in New York, upstate New York, and he's making all of his own office equipment here now. He's made that decision. And there were examples of other companies doing that. What I want to mention along with this, though, is that governments like India and China also are having their own made in their country initiatives. And so this is going to get real interesting to see how that plays, you know, worldwide. I think this has done a real number on just-in-time, though, delivery. It's a whole different ballgame now. Virtual meetings, virtual trade shows, we all got used to those. Nothing like attending a German trade fair virtually when they start at 10 a.m. and I have to be on at 4 a.m. That was a lot of fun. It really was interesting, though, to see that. Hybrid events like this one, 5 years ago, who would have ever thought, you know, but it's great to be able to do that. Remote work, we were just talking about working from home in our jammies, and it's nice to have that option at times. Work visas were impossible or delayed because our consular sections were closed down or working remotely. We had situations during COVID where US companies that had purchased large capital equipment from another country needed those engineers and technicians to come in and set that up so they could get that up and running, and it was impossible for them to get those folks here. So we worked on that. I really don't know the outcome of some of those because they weren't in my area, but I do know those problems happened. And then we all know a lot of people decided to retire or go to different jobs during COVID. A lot of people that probably would have kept working made the decision to just go ahead and exit. And we still have staffing shortages. So for us, that meant no in-person calls, which was devastating to me and a lot of my colleagues, because that's how we get to know our companies and our partners. And so like everybody else, that was very difficult. We were not allowed to work outside of home by law in the US, and that included not being allowed to go to our offices. What I found fascinating was that we found out there were some countries where people were by law not allowed to work remotely, like Germany. And so don't know how that was resolved, but it was, because all of us worldwide had to work from home. We offered for a time, we do charge fees based on cost recovery for our services, our partner searches, and we offered no cost partner searches during that time. But we had to kind of stagger those because in the foreign countries, it was very difficult for our colleagues to reach businesses. So there was a kind of a limit on how many of those we could do. And matchmaking services, of course, became virtual. And I'll talk about those, our matchmaking services and trade shows. And we had an internal worldwide map showing shutdowns and who was in the office and who was not and what was going on with COVID. And like I said, our foreign colleagues were very limited on reaching foreign firms. So post-COVID, I know we still have issues, but it's really great that we have trade missions now that we're working on. We have one right now occurring in Southeast Asia for manufacturing. Last month, I was able to go to a big manufacturing trade show in Chicago called INTS. We brought in 5 foreign colleagues, Brazil, Taiwan, Mexico, India, and Turkey, and they brought a total of about 250 foreign businesses to the show. I think there were about 2,200 exhibitors at this show. It was pretty big. And so we were able to conduct some B2B meetings. We still work virtually. We still hold meetings virtually, unlike, like never before. But then we're also now able to do in-person programs, services, which I'll talk about, some of those that we do. A trade mission that was pictured in the last slide that I want to mention, it's an excellent opportunity for U.S. business, is Trade Winds that will be held in Southeast Asia this year. And what that means is we take a group of companies on this mission, and they actually sign up for various options based on what they want to do. We have B2B meetings we can set up, spin-off trips to Vietnam, Philippines, Singapore. We'll have a conference in Bangkok, and that's a great opportunity for visibility and networking. We have programs for that. And then we also will have spin-off trips to Malaysia and Indonesia. And it's just a great opportunity for a small business to have visibility and meet these folks in these countries. Our Gold Key service is one of our premier services. I think it's a valet service. The US company gives us specific dates that they'll be traveling to a country. We'll set up meetings for them. If they need us to go with them on the meetings, we will do that and help with any language barriers. But the idea being that we're going with you on meetings to meet qualified companies, and we have screened those, and we have your best interest in mind. When we go with you in those meetings, we're there for you to help you with identifying potential partners.
Yes, this is the second of 9 codes, and again, you can write this down, but these codes are in the materials, so you can print them later too and write them down.
Our international partner search is also an effective matchmaking service with the idea that you aren't going to travel right away. We put together the same kind of list of contacts for you based on a lot of discussion with you, what your needs are to find a distributor, an agent, and partner, and then hopefully maybe follow up later with a trip to that country once you have that list, and we will help you along with all of that. The single company promotion, I'm actually working with a couple companies on this. This is a newer type of service we've had in the last several years that I think can also be very effective depending on the company and their needs. It's a promotional event. We have formal invitations we send out from the embassy or consulate to invite a group of potential partners or buyers to come on a certain date to a location. Maybe it can be wrapped around a trade show, maybe it could be a technical seminar, a press conference, include refreshments. I mean, you do have to pay for, additional items, but depends on the company's needs and what they want to do. A lot of times, and this is an ambassador's residence, I got this photo online, a lot of times we'll try to provide a venue like this that's no charge to the U.S. company so that they have a nice setting and it doesn't cost them any additional funds. So like I said, IMTS in Chicago last month, we held counseling sessions where we counseled U.S. exhibitors at the show on the markets. My colleagues from Taiwan and India and all the others counseled U.S. companies while they were there on their markets. And then B2B meetings, we did set up quite a few of those in the time that we had. We have other programs we use to help our U.S. companies. Initial market check is a snapshot of a market. It's $350. It's an opportunity for us to contact 5 to 10 foreign businesses, get their input on working with the U.S. company and gauge their interest, and then provide some industry information, industry trends on the market, and wrap that all into a brief report that can be used to decide whether to go ahead and go into a market with some of our other services. Our international company profile is a background report. We have a full report and a partial. The full is where we interview the foreign firm and ask them for their financials and get their business reputation, their credit history, and put that into a report. And then our partial is a report based on publicly available information that we can pull together. We do get leads from our foreign offices all the time. Those are very industry specific. So they may be looking for our aircraft parts, or they may be looking for medical supplies. And we get those leads from our colleagues abroad and send those out to companies and to partners. Virtual introductions, we're still using MS Teams and WebEx to do that. Introductions at trade shows, like I mentioned earlier. And reaching underserved businesses has been more of a goal in the last couple of years. We have programs under our Global Diversity Export Initiative program. We want to reach veteran-owned, women-owned, minority-owned, all kinds of other businesses that aren't normally in the mainstream, reach them. And in the last year, we partnered with Goldman Sachs on their Small Business 10K program, which they had about 11,000 participants. And we counseled a lot of those companies on what we do to help them with their business planning and educate them on what we do so they can grow internationally. So this is kind of small on the screen, but this is an example of our international company profile. It's a little dated, but I just want to give you an idea of how detailed this gets. And at the end of these reports, we actually give you a recommendation. We actually give you an assessment on whether or not you should work with this company. I have had some of these that turned out negative, and it did help a U.S. company avoid problematic situations. So we can't do what we do, reach all these companies, without our partners, including other government agencies, SBA, XM. We do work with BIS on any enforcement issues. States, state of Ohio has a trade division, SBDCs, we work with them closely. Chambers of commerce, economic development organizations. I just did a panel yesterday morning with the University of Oklahoma that was about different service providers, including us, what we do. Business incubators, some of you may be familiar with the one in Dayton that's now at the Hub in the arcade that helps small business, startup businesses. And manufacturing extension partnerships, we call them MEPs, to help manufacturers with lean manufacturing and issues like that. They have them throughout the state of Ohio and other states. And if you've ever worked with Fastlane in Dayton, that's an MEP. Universities and colleges, UDRI, other universities, including my satellite office at Wright State University, where we have a partnership. And of course, we work with attorneys and CPAs and bankers and freight forwarders. Any of these service providers that are working with these companies to help them, we want to help them develop an external team to cover all aspects of what they're doing. Trade associations and industry associations, big ones like national, like NAM, but also locally like DRMA. They've been great about sending these leads out that I mentioned earlier to their members. We have great resources through people in Washington, D.C. we work with. This just came out, this guide to doing business with multilateral development banks. I would suggest you contact me or any of my other colleagues if you're trying to find some of this, because it can kind of be overwhelming. We have a trade finance guide that was just put out last month or month before by the gentleman who worked in Washington, but he's now the director of our Toledo office. So I mentioned trying to reach underserved businesses. My colleague down in the bottom left is Chris Simpson. He's in Cincinnati. He put this webinar together with a business owner on the right, Zach Green, who's a vet who started his own multi-million-dollar business now called Vets Go Global to reach veteran-owned businesses. And they did this last month. We have a road show that our Director General is starting up again this year. He did it last year, called Building Bridges to Global Markets. It's specifically to reach minority-owned and women-owned and rural and veteran-owned businesses, to tell them what we do and get these partners together. This one included a stop in Cleveland, Ohio. And then I mentioned our Global Diversity Export Initiative. This is a trade mission for women in tech that will be happening the end of this month and earlier next month in Netherlands, Portugal, and France. So another trade mission that gives you visibility, these firms visibility and some outreach. And then here's another CLE CPA code, so Roger doesn't have to do that again for us. Just make note of that. It's in your materials. We do have other parts of commerce that Roger can tell you a lot more about, like U.S. Patent and Trademark Office. We have a website I wanted to mention, stopfakes.gov. If you feel like your technology or your products are being copied, you want to check that out and talk to us and work with an attorney, actually, is the best recommendation. In the last several months, I'm sure all of you are aware of the issue with Ukraine, with Russia. And so we got a lot of calls from companies not knowing what the restrictions were for, we work with BIS because we want our companies, as I mentioned earlier, we want them to stay out of trouble with export laws. And we, of course, work a lot with BIS because it's commerce. There are probably about 11 government agencies with their own version of export laws. But because we're commerce, we work a lot with BIS and educate our companies on that. But we did get a lot of calls when the sanctions for Russia were put in place, the increased sanctions, I should say, about what's allowed and what's not. And the thing that I want to say that was different with this situation we've never seen before is normally the products we're talking about with BIS are dual use. So they're commercial commodities that can also be used in military applications or warfare. But in this case, what happened was they published a long list of harmonized codes that are normally no licensing, nothing special required. But these products, equipment, parts of machinery are now restricted for Russia and Belarus and require export licensing if you can even get it. And so that was very different and confusing. And I got calls like, gee, we have a buyer in Estonia. It will end up in Russia. but since we're selling to Estonia, is that okay? And the answer to that is no, because if it ends up in Russia, it's the end use and the end user they look at. Supply chain has become something else on our radar. We recently, there were laws put in place about knowing in your supply chain if you have forced labor, human trafficking. And so we actually have a group at Commerce that can answer questions about how a U.S. company can monitor that, how they can check to make sure that they don't have any of that in their supply chain. So that's become an issue lately. And yes.
I have a question about that.
Sure.
So is there any list of like standard or anything like that that is referenced when you do those kinds of checks when it comes to social responsibility and international labor laws and that type of thing?
That's a good question, Ben. And I was looking at this cool little video that they have, which is really helpful. It kind of explains how you do that. And I have to tell you, that would be where I would pull a colleague in from this group to talk to you about it, because I'm not specialized in this. But I don't know if that answers your question.
No.
There's a checklist and things you can specifically check to make sure that you don't have that. And maybe even some kind of proof because of potential audit. But that's a really good question. But I can look into that more, later. But I would suggest going to this website, and I'd be glad to give it to anybody if they need it, and look at the basic information, and then any specific questions, I'd be glad to get you anyone in a discussion about how you actually do that. Because this helps you understand the laws and regulations and identify red flags and develop a due diligence plan, kind of like with export compliance, how you have to set that up in-house. Our website is, trade.gov/CS, or you can go to core.gov. It's great information. It's a lot of information. That's why I really recommend you work with someone in our offices locally. You can find all of our offices in the U.S. on this website. You can also find all of our foreign offices, but we act as account managers. I would encourage you to work with us locally if you can. And we are rated on your success. As a small business, we're rated on your success. And so our commission is your testimonials. And these are 2 companies locally that were kind enough to let me do that, use those. But the thing is, we want you to be successful because we're actually rated on your success. And we don't want to waste your time on a market that won't work. If you go to YouTube and type in U.S. commercial service, you get all kinds of videos of companies that are talking about how they've worked with us and what has worked for them. And I think that's it for me. My contact information is there. So I am more than happy to answer questions. Or I would say at the end of this, though, I just want to say the next new normal is not, there's no normal. As we all know, because in this business and international, it changes all the time. So I would say there's no normal. There may be standard practices, but it changes all the time. So be in touch with anybody here in this program today.
Debbie, there is a question for you. It's how can the commercial service help a company determine what markets have the most potential?
Thank you, Ellen. I would say there are a variety of ways. We have data that we can look at. We have market research we can pull up. Companies a lot of times in a specific industry know where their competition is and they know where to go. They give me a lot of clues that way, but if you're getting a lot of inquiries from one country, that also it may be an indicator. I know some companies I've worked with have a lot of inquiries coming from India, but then when we boil it down and look at what they're asking for, the pricing has to be so low that it's not possible. So it really depends on the industry, but also I would say that's where we come in, is having people on the ground that can really help us identify the potential. And so, yeah, I would just say contact any of us to help you with that. Thank you.
There was
Thank you,
another
Debbie.
question,
Was there?
not for
Okay.
you, but
Sure.
it was, I was not able to see the codes. How are we going to be able to put them in the form? In a few days, you'll be getting the PowerPoints and the codes are all embedded in the PowerPoints.
And we'll also, on the last slide today, we'll actually recap all of the codes.
Well, good morning, everybody here in the room and online. My name is David Coomer, and I'm a shareholder with Clark Schaefer Hackett and Company. And I'm here with a couple of my colleagues, Natalia Magnuson and Lisa Wineland. And we're going to talk through today just some general considerations that we take clients through as they're beginning to look at taking their business abroad. Those are going to be kind of finance and accounting type issues, and then we'll kind of scratch the surface on some of the tax issues that obviously companies need to be aware of as they're considering going abroad. Obviously a very broad topic. Each one of these things we're going to cover today could be probably a presentation in and of itself. And so, the hope here is just to create some general awareness so that, as you're new to this, you start to get used to the questions and the things that you need to think through. And I guess before we do that, I want to thank Thompson, Hine, and Deb with the commercial service for including us in this presentation. I think this is a great resource for companies that are looking at starting abroad. I'm going to start with a little bit of an introduction about Clark Schaefer Hackett for the folks that are not familiar with us. I won't go through the bios here. You guys can read those. I'm a audit shareholder with the firm, and Natalia and Lisa are both part of our tax team. In the firm, we've got a group of specialists that help our clients that are operating international deal with really the US based compliance and reporting issues associated with that. And we work with partner firms across the world. We belong to an association of firms called AGN International that is got about 11,000 collective employees and is in 60 different countries across the world to help with very specific in-country issues. And so that's kind of how we help our clients deal with kind of the on the ground issues associated with doing business internationally. Clark Schaefer Hackett itself, just for those of you that aren't familiar, we've been around for 84 years. We focus primarily on closely held businesses, kind of in that small to middle market space. And just by the nature of where we are located here in Ohio, with Ohio being one of the largest export states in the country, a large portion of our clients have some element of international business. Whether that's exporting or foreign subsidiaries, we deal with all of those types of issues and help our clients through those things. Really from a service line standpoint, the firm, obviously very diversified. You've got your typical tax and assurance services. That's kind of the first bullet point on there. That's probably about 2/3 of what we do. And then the rest of this is really what we consider kind of our business advisory services, things like technology consulting, HR consulting, and those sorts of things. Just really trying to help clients with any kind of a business need that they may have. Let's see. Okay, so here's the next CPE code. I think Roger said we'll be an opportunity to recap these here at the end, but you can jot that down as we go through here. So when we talk about service offerings specifically related to international and kind of the finance and accounting and tax area, these are some of the things that we're working with clients on. Obviously making sure that they're addressing the financial reporting challenges of working abroad and planning appropriately for that. And then we'll touch on a lot of these tax concepts, again, in a very high level detail as we go through this. So I guess to kind of start with kind of the meat of the presentation here, what I wanted to kind of walk through to start with was, what do we see? Why do companies start to go abroad? How do they go about doing that? What are the different ways that they do that? And really, what are some of the just practical considerations that need to be thought through as you're planning this process, and what are some of the resources that are available to you as you go through that? And so, oftentimes what we see at the beginning of this is, a company starts exporting, but because they've got a customer that's gone abroad and they need, product overseas or something along those lines. Think of a customer setting up a facility in Mexico and needs, just-in-time inventory or something like that, and they need you to set up a warehouse down there to supply them. That's really kind of where we oftentimes see companies starting to dip their toe in the water in terms of exporting and that sort of thing. Obviously, there's also the opportunity to gain market share if you've kind of tapped out the U.S. market here. We have a huge economy, but it's really only 24% of the global economy. So there's 75% of the rest of the world out there to sell to. So companies that are looking for opportunities to grow, start looking outside the U.S. from that perspective. And then, obviously competitive advantage. This is, you think of looking for opportunities to take advantage of lower, labor costs or material costs in different markets. So thinking, Asia, Mexico, some of the Latin American countries, things of that nature. Just looking for a competitive advantage. And then I guess lastly, this is something we're starting to see more of, and I guess Clark Shaver can speak firsthand for this. This is right now with talent shortages and the difficulty finding skilled work. A lot of companies are looking abroad for talent, and so Clark Shaver, one of the things we've done in the last year is open an office in India, where we have hired I think about 25 chartered accountants at this point to help service our clients here in the U.S. So a little bit different kind of viewpoint than exporting, but again, a strategy that a lot of companies are looking at to deal with kind of the talent crunch that's affecting a lot of different businesses these days. So again, just general thoughts on why different businesses are expanding internationally. Again, different ways that companies are entering the markets. Oftentimes you'll start with maybe a sales rep. That could be an internal salesperson going around and visiting potential customers abroad. That could be a contract sales representative in a foreign country. We also see oftentimes distributorships set up where you're exporting your products to a distributor, and then they're taking it from there to the market. Deb talked about this a little bit, but one of the great resources of the commercial service is the ability to provide research and matchmaking and connect companies with on the ground partners that can help you with again, sales rep, distributors, vetting them and connecting you. It's one of those things that a lot of small and medium-sized businesses don't have the resources to do on their own. So having that resource is tremendous. Probably the next step down the road here in terms of complexity is a joint venture. So that's looking for truly a partner in the foreign market that is familiar with it, and you may be providing products and capital, and they're using their familiarity with the market and their connections to partner together and sell product. The other area here is we talk about acquisitions. I don't know how many people on the line have been through an acquisition, but any acquisition is complex, and you start talking about international acquisitions, it becomes even more complex. But that's also a kind of a viable option in terms of entering a market. And then lastly here, I say greenfield, really referring to starting from scratch, right? That's where you're going in and setting up an entity and hiring employees. And again, this hopefully as we go through this today, the main takeaway you get is that building a team of advisors around you is critical when you're operating abroad. And so this is where you're going to need in-country experience. You're going to need legal. You're going to need accounting experience, export support, all of those things to help you make sure you're complying with things, all of the different regulations and so forth. So again, ways people enter the market, generally speaking, is if we have clients that are looking at potentially beginning, to operate overseas, these are the things that we're talking about with them, and making sure that as they're building that team of advisors, these are the things that they're thinking about and evaluating. And in a couple seconds, we'll get to a slide where we kind of talk about developing a business plan and that sort of thing. But we all know that just operating within the U.S., we've got 50 different states with all kinds of different laws. So you take that outside the U.S. into different countries and complicate that with different languages and different cultures. Obviously, those are things that need to be, you need to have an awareness of as you're going through and doing your planning. And so, the other part of this is understanding just the government and the financial systems. Us as accountants, this is kind of where we geek out on, the planning side of things and modeling the optimal structure of how you set up your entities and, taking advantage of tax treaties and that sort of thing. And then also understanding we all do this because we want to make money, right? We're doing this to make money at the end of the day. We want to get it back to the U.S. Most of the companies that we work with aren't Apple or Microsoft with billions of dollars parked overseas that they don't intend to bring back anytime soon. We want to bring that money back here to the U.S. And so making sure that things are structured appropriately so that you mitigate, taxes on that repatriation of those funds, that you're minimizing currency risk, and doing what you can to avoid losses there. So again, a lot of the things that we talk through with clients, here's the next CPE code. Give you one moment to jot that down here, and we'll move on through here. So again, talking about the business plan, evaluating the market and the competitions is no different than building a business plan for any other kind of venture, right? You just have some unique considerations that you have to build into it. And, again, I kind of put the plug in for Deb and the U.S. Commercial Service. They can be a great resource on providing a lot of the research related to the market and the competition and those sorts of things. So certainly would encourage you to reach out to them. I think the other piece to this, though, is, again, is the financial planning aspect of it. And so depending on how you intend to go to market, you may need a significant capital investment. You may be putting equipment in the foreign country. You may, what have you. You certainly are going to have an impact on working capital. So if we're exporting products, you're going to have to fund the inventory that you're shipping overseas. It's going to take longer to get there. It may sit for a while before it sells. So you're going to have to consider, how are we going to make those investments? And will your domestic bank be willing to fund those investments? It's important to work with a bank that is comfortable in the international space. There's also other resources out there. The SBA has some great programs with respect to export, support with working capital and CapEx type loans that that companies can qualify for. And so those are things that you need to consider. And so the next page was just okay. Yeah, the next page here was just kind of trying to put this into perspective and showing a really simple working capital example where, let's say, you typically on your domestic business need 45 days worth of working capital to fund operations. And let's say that you anticipate that you're going to have 2 weeks worth of inventory sitting on a boat, before it gets to the market and you can sell it. It's going to add, roughly 14, 15 days to your working capital requirements, which, you look at that, that's a 33% increase. And so what is your strategy to fund that increase? Are you going to have capacity on your line of credit? Can you get customer deposits? And the additional cost associated with the exports, are you able to recapture that through pricing with the customers in the foreign market? So you're going to have financing costs related to working capital, shipping, all kinds of compliance costs with export controls and things of that nature. So just, again, trying to stress the importance of modeling this out and making sure that you really understand what you're getting into. Then, the other part of what we try to talk to clients about, as they're planning this out, doing the business plan and modeling things, is really risk management strategies. And, obviously when we start operating outside the U.S. or making investments outside the U.S., you have currency exposure. And that can be as simple as the transactional exposure on your receivables. It can be, from a big picture, the exposure related to your investment in that entity, and that investment is going to be denominated in foreign currency, and when you translate that back to U.S. currency, depending on what happens between the exchange rates, you could have a great year in that foreign market, and if the U.S. dollar appreciates tremendously against the foreign currency, you could end up with a kind of a paper loss at the end of the day because of that. And so we talk a lot to clients about implementing hedging strategies and where they intend to absorb the currency risk. Oftentimes, when you set up an entity overseas, it's not as robust from an administrative standpoint as maybe your U.S. operation. So a lot of the times we encourage our clients to absorb the currency risk here in the U.S. and actively manage that with a hedging strategy. I've seen situations where foreign subsidiaries that are really operating more as a distributorship with very low margins get in big trouble if the currency turns around on them and they aren't generating the cash flow to fund the receivables back to the parent. And it really hurts the parent because they're dependent on that cash flow to pay their vendors. So this is an aspect that is really important to kind of plan for. The next piece here, again, obviously there's always credit exposure when you're dealing with customers, but when we're dealing with, international customers, that introduces a whole nother element to this. And so, some of the things that we talk about with clients are, if you can get some of the price up front through deposits, that helps, that mitigates some risk. We have clients that are large equipment manufacturers that oftentimes use letters of credit. So that's another way to secure some of the receivables by really swapping out the credit of your customer with their bank. So that's an approach. And then credit insurance is another opportunity here as well. Ex-Im Bank will offer credit insurance on foreign receivables. So that's another way to potentially mitigate some of this risk and some of the things that we talk to customers about when they're going through the planning process here. So let's see here. And then I guess, real quick before I hand things over to Lisa, and Lisa's going to go through and kind of touch on a lot of very high-level tax concepts. Just from a financial reporting perspective, if I've got any accountants on the line there, when we start setting up entities abroad, and those entities are owned by the U.S. parent company, we've got to consolidate those entities into the U.S. financial statements to comply with GAAP. And so, that creates all kinds of challenges related to translating foreign currency and the foreign language, and the potential that foreign country has different accounting standards than the U.S. So, it's really important that you familiarize yourself with those and don't underestimate the complexity that will be involved with maintaining, a compliant set of U.S. GAAP financial statements because of that. So, I'm going to go ahead and turn it over to Lisa and let her kind of start on some of the tax topics. I'm hopeful that when she starts talking, we don't get a bunch of feedback here. So I don't know if I need to mute this.
Good morning, and thank you, David. Can everyone hear me okay?
We hear you here. Excellent.
Well, thank you, and excuse me, get the frogs out of my voice here as I've been sitting listening to everybody else present. So as David mentioned, we're now going to jump to the exciting tax side of the fence. We find it exciting. We know most people don't find taxes that exciting, but they are very important and key considerations when you're looking to do business outside the United States, and often do tend to be some of the first things that people think about. What is this going to cost me, or how do I prevent myself from getting in trouble in the foreign country and getting all these weird taxes thrown my way that I don't know what to do with. Kind of starting off with kind of the first typical phase of doing business internationally for most of our clients, especially on the manufacturing front. If you're, good old-fashioned manufacturer selling widgets, and typically your first international touch point is going to be not having any actual boots on the ground in the foreign country, but exporting your product into the foreign country. And we do often get involved with clients at this stage because it is an important first stage. So the important thing to kind of point out at this stage is that when you're just shipping the product only, just for those of you who are familiar kind of with what happens here when you're selling across state borders here in the United States, typically there's no tax consequences really either in the US or in a country that you're selling into if you're just shipping stuff across the border. One thing though to keep in mind is that there are actually some nice export tax incentives that you can get if you're aware of and you're set up properly in the right type of business that you can take advantage of, and we'll cover those in more detail later. But just want to kind of mention that it's not all bad news when it comes to taxes. There are some good things out there. So the next natural kind of progression, as David kind of already discussed, is that okay, you're shipping widgets into the country. So the next natural progression is if your widgets take off and they're selling really well, now from a broader marketing plan strategy, you might say, well, gee, I could probably, this looks like a really hot market for me. I could do a whole lot more if I actually send some of my sales guys into the foreign country to help boost more sales since things are going well for me here. So now you then have what we refer to as boots on the ground, and that's where the tax situation starts to get a little bit more complicated. So I think, as David kind of mentioned briefly, the U.S. does have a tax treaty system on the income tax side that kind of lays out a roadmap of the do's and don'ts that are agreed to between the U.S. and its treaty partner countries, which are most countries where the U.S. is openly trading with. There are a few countries out there that don't have a tax treaty, but most do, and most of them, some are more favorable than others, but generally most of them have the same general framework. So some of the do's and don'ts that the treaty allows you to do, there is actually a pretty good expansion of being able to do a fair amount of things when you're selling a product before you have kind of a true, what we refer to as taxable presence in the foreign country. So here are things that you can do without creating a taxable presence in the country. You can have sales guys, traipsing around the foreign country, knocking on doors, selling widgets, to kind of use a more old-fashioned outlook to things. And nowadays, of course, you're doing most of that virtually. So quite honestly, kind of delays some of this stuff and considerations somewhat if you're still doing that mostly virtually from the U.S. at this point. But in an old-fashioned sense, if you actually want to go out and start calling on your customers in the foreign country, especially as Deb was stating, now that people are actually able to meet live and in person these days. Often that personal touch still works well, even when you're expanding internationally. So the next logical step typically is, okay, I'm selling product in the country, and I've got salespeople traipsing around. Well, if I am selling very well into the country, usually the next normal step is, gee, I'd really like to be able to store some inventory in the country so that I can more efficiently deliver product in a more timely fashion in the foreign country. So unlike on the state front where this starts to become a problem, you can actually, the treaties do allow you to actually have a warehouse where you can store and display inventory and use that to deliver your goods to your customers without creating a taxable presence in the foreign jurisdiction. And that's kind of whether you're leasing inventory space from somebody else or actually having your own warehouse. So then the area that gets a bit thornier, this what we've been talking about so far has been more the bread and butter manufacturing crowd that's selling a product, but usually it's not that nice and neat. Usually what starts to trip people up is when you start performing some type of service in the foreign country, and that can be installing the product on your customer site, doing some level of training, something that goes beyond kind of just the mere solicitation of sales and the handling of inventory. And this is where you kind of flip to actually creating a taxable presence, for yourself. But again, there's still some provisions in the treaty that kind of help you with that if it's more of a short-term thing. So if you do have some construction and installation that needs to take place for your situation in the foreign country, a lot of treaties do provide some relief if that project is under a certain time period. You can be safe from creating a taxable presence. And also kind of being mindful of if it's usually more tax efficient if you can get away with maybe using some independent contractor help for installation and projects to the extent that works for you and your business. It's when you obviously when you start getting to the point where you have employees, your own U.S. employees traipsing around in a foreign jurisdiction, doing something other than sales, or a dependent contractor. So when you kind of start getting into those types of things, you are most likely starting to create a taxable presence, or the treaty lingo for that is permanent establishment, or PE for short. So okay, what happens next now? Okay, I've got employees now in the state doing taxable activities. So now what do I do? So just be aware that this is definitely where you need to really start putting some tax planning into play. To see if this level of activity kind of rises to the need where you need to start thinking about, okay, am I going to be setting up a permanent office here for these people? Do I have people working in the foreign country out of their homes? If you have and usually those are the two main ways we see things occur, either just with U.S. employees maybe temporarily in the foreign country, or hiring a foreign national to work from their home. Well, if you hire that foreign national to work from their home, you now have basically opened an office in the foreign jurisdiction. So just because you aren't leasing space or doing something more meaningful to open an office, that does create a taxable presence for you. And if they're now your employee, you got to figure out how to pay them in that foreign jurisdiction. So that's where typically one of the first things that you need to do is to start figuring out, okay, well, they need to be paid. I'm using not U.S. payroll, but the payroll system in that foreign country. And so you need to make sure that your payroll provider can help assist you with that. And if they can't, get in line with some professional services firm that can do that for you, so you get off on the right foot there. Also be mindful that if you do have US employees going across the border on it, even if it's just, for a day or two at a time, periodically throughout the year, your employee could be personally taxed in the foreign jurisdiction. So again, if you have a US employee who is starting to work a good bit beyond just the sales function in the foreign jurisdiction, it's important to possibly start putting them on a foreign payroll, and so that you don't get them personally in trouble in the foreign jurisdiction. So some other things that kind of come up with in the earlier stages that become can become a problem earlier on. It's not just income tax that you have to be concerned about, but there are some non-income tax considerations. Most of you might be familiar with the term value-added tax, or VAT, and that's a concept that we don't have directly in the United States. The closest thing that we have, it's very similar to our US state sales tax system, except that it's a national level tax with much higher tax rates, and it's also on services. And unlike the income tax that we just spoke about, there is no treaty system that protects you from these taxes. So it's again, generally speaking, you can, so you're kind of up to the local country rules as to when those taxes do kick in. And most countries outside of the US do have this value-added tax concept. And often we see clients who are just selling product into the foreign jurisdiction starting to get questions from their foreign customers about, gee, why are you not, assessing VAT on my invoices? So sometimes people unwittingly start, messing with VAT when they really don't need to be. So it's important to kind of understand and get some local country tax help to understand when those taxes kick in. So now kind of the next evolution is, okay, now you have a full taxable presence, and you're purposely meaningful, things are going great for you, and it's now at the point where you're ready to have a local, you've gotten to the point where it makes sense for you to actually set up some type of a foreign entity to work your business in the foreign jurisdiction. And again, typically this is where, when you do have a taxable presence, the first thing, well, and sometimes this happens accidentally, is that if you don't have a foreign legal entity set up, what you basically end up with is something called a foreign branch. So you can, have your U.S. company be, the taxable entity in the foreign jurisdiction, and when you do that, you create something called a foreign branch for your U.S. company. And so the main thing, and you can do that, and sometimes that is the best way to go. And depending on the situation and what you're going to be doing in the foreign country. Just know that it can get a little bit messy on the tax side because you don't have that kind of clean separation between a foreign entity and the U.S. entities. You have to make sure that you keep clean books and records for the foreign branch activities, because then that has to get plopped on a foreign country tax return. And your U.S. company will need to get registered properly with the foreign jurisdiction to be able to remit taxes. Or sometimes even just if you are doing treaty-only protected activities, oftentimes it's a smart idea to go ahead and file what's referred to as a treaty-protected tax return in that jurisdiction. Just say, hey, yeah, in case you find out that I'm here's what I'm doing, and I don't owe you any tax, and here's why. So kind of a preventative measure, and sometimes it's smart because that way it kind of gets the statute of limitations running, so that if that's going on for some time and they try to come after you, they can only go back so many years on you. So if you go beyond, if the branch isn't for you, or you need something a little bit meatier, then the next thing to do is to start looking into, okay, I need and want to form an actual legal entity in the foreign jurisdiction. So what do I do now? So this is where you definitely want to get some local attorney and tax professional help to make sure you make the right type of entity choice, and don't pick the most expensive kind that has all kinds of restrictions. Most, if you're in the small and mid-sized market, typically most foreign jurisdictions do have kind of a limited liability company type of option, which would be kind of similar to our partnership, structure here in the United States, where you will find, so for most of our U.S. small business clients, most of them are in some type of what we refer to as a flow-through structure, which means you're either structured as a partnership or an S corp in the United States to be more efficient from a tax perspective and not have that double layer of taxation that a regular corporation can bring you. So that's why it's kind of important, depending on how you're structured in the United States, as to how what type of legal entity you pick in the foreign jurisdiction, and then how you and then you actually have some important planning that you can do on the U.S. front on how to treat that from a U.S. perspective. So some of the important considerations, again, to kind of prevent this double taxation problem and make things the most efficient from a tax perspective, kind of goes back to some of the concepts that David was speaking about, and that is, typically if you're a small to mid-sized operation, you're not wanting to leave large sums of money that the company is making in the foreign jurisdiction, in the foreign jurisdiction for a long period of time. You want to be able to get your cash back to the U.S. to help grow your business in the U.S. In order to do that more tax efficiently, and again, if you're a flow-through entity in the United States, most of our clients, and again, if you pick the right type of entity choice, you can actually have a cool election that you can make called a quote-unquote check-the-box election, which basically allows you to make, for U.S. purposes only, does not change the treatment of the company in the foreign jurisdiction, but for U.S. purposes, you can actually make an election to allow your foreign entity to be treated as a flow-through structure as well. And so what that allows you to do is, to the extent that so probably most importantly, when you start out, all companies think they're going to go go to a foreign entity, a foreign country, and make fistfuls of money, and things will go well. Well, especially if you're kind of going the startup mode, or the greenfield site that David referred to. Most people do end up losing money when they have a startup venture. And so the nice thing about having your business in a foreign country coming back to the U.S. in the form of a flow-through is that you could take advantage of offsetting those foreign losses against your U.S. income, since your U.S. parent is typically going to be funding those losses in the foreign jurisdiction. So that allows things to be much more tax efficient earlier on. And then in the future, when the foreign entity hopefully does make fistfuls of dollars for you, you can then get a foreign tax credit for the foreign tax that's paid, and take that against your U.S. taxes, and that kind of eliminates the double taxation. So alternatively, if you don't want to bring the funds back right away, or if you are structured as a U.S. regular C corporation in the United States, typically you're going to leave your foreign entity treated as a corporation for U.S. tax purposes. And what that means is that when you do eventually bring the tax dollars back, especially if you are a flow-through in the United States, you will have some level of double taxation, because you're going to pay taxes in the foreign jurisdiction, and then you cannot offset that with a foreign tax credit against your U.S. taxes. If you're a U.S. flow-through entity, so that's where it's important to kind of think through those things. And the nice thing about these so-called check-the-box elections is that you can change the election over time. So if at first you want to make sure that you're taking advantage of those tax losses, but then you turn profitable, and then maybe, hey, things are going well for me, and I'm over in Europe and I want to start expanding all over the place, then you might decide, okay, I do want to leave my money parked over here for expansion purposes, and then then maybe it makes more sense to go to have the foreign entity route. So the and I guess this is kind of a good segue into the next into our next slide of talking points. So so if you do keep your company treated as a foreign corporation, and this kind of goes back to kind of the reference that was made regarding Apple. Oftentimes we get these questions right off the bat saying, gee, I hear and read how Apple and all these bigger companies are able to permanently save money by doing business in low tax jurisdictions. How can I do that and never pay tax on my back in the U.S. on my foreign earnings? And it's so a couple of important things there. I mean, So if you were structured the right way and you were able to part with your money and never really want to bring it back, like Apple can do, and most importantly, have a true presence in these low tax jurisdictions where you have true operations. Yeah, there used to be a way through some tax planning that you could do these things, but it's important to know that a couple of years ago, there was a big tax act change in the United States that kind of changed the way mostly how C Corps are taxed worldwide, and that was actually favorable to the regular C corporation. But in exchange for that, in order to kind of shut down some of the tax planning shenanigans that the U.S. government was knowing was happening and was not liking for obvious reasons, they added all of these kind of slap on the wrist tax provisions to make foreign earnings taxable sooner, or at least make sure that there's a certain minimum amount of tax that a foreign corporation pays. So let's see, I think we're on the wrong slide here, folks. We maybe want to go back a slide. But there's several important tax concepts then to kind of understand when you do have foreign earnings that are either parked in these low tax jurisdictions. There's a tax referred to as the GILTI tax. I'm sorry, could someone advance the slides back one, please? Or I think we're still sitting on the wrong slide here.
Lisa, I'm sorry, we're having a little bit of a technical issue here with the laptop we're working off of. So.
Oh, okay. Yep. It looks like looks like I'm done. we're on the question slide now.
Yeah. So I would just keep plugging away there.
I'll just keep going. Okay. So. So there's a couple of what we refer to as kind of anti-deferral mechanisms in the U.S. tax code that some have been around for many years, dating back to the Kennedy administration. And one important one is brand new as of a couple of years ago. In the tax world, they're fond of coming up with these cute little acronyms. So this one slaps you right upside the face. It's called the GILTI tax. So nobody wants to be in trouble with the GILTI tax, just even from the name of the acronym. So basically, again, what this is if you are parking, if you're doing business in low taxing jurisdictions, and you are treating your foreign corporation as a corporation instead of a flow through, the U.S. government wants to make sure that you're paying at least some baseline minimum amount of tax. This was an extremely complicated new provision that they put in place. The good news, with some careful tax planning, you can greatly mitigate this tax, or in some instances, if you are actually doing business in a higher taxing jurisdiction, you can make an election for it not to apply at all, as long as you're paying a certain baseline minimum amount of tax in the foreign jurisdiction. Then that helps get you around these so-called GILTI tax. And then there are two other anti-deferral mechanisms that have been around for quite some time that kind of have more to do with the types of earnings, and not necessarily where you're doing business, but just kind of the types of earnings that you have. If you try to take a bunch of investment income and try to park that into a foreign corporation and say slap it into the Cayman Islands where there's no income tax, the IRS is going to say, no, you can't do that. You owe me tax on that, as it's earned, because it's investment earnings. You can't just hide and not pay any tax on that just by parking it into a low taxing jurisdiction. And so that's a regime referred to as subpart F income. That's been around a long time, and there are other buckets of subpart F income, like if you're in the insurance industry, insurance business, certain foreign insurance income is also part of the subpart F regime. So if you have like something like, we have a lot of clients who have foreign captives, captive insurance companies. So anything earned offshore in those captives can some of that income can potentially be taxable currently rather than deferred. And then there's this wonderful animal called a passive foreign investment company, or PFIC, and that's again similar to the first bucket of subpart F income. If you have investment earnings, in a foreign corporation, nothing else, then you can end up being, referred to as this PFIC thing that has this what we refer to as a sting tax. That it's a real egregious tax that's actually even way above and beyond what the normal tax would be. So you definitely want to stay out of trouble with that one. There, we're finally on the right slide, and perfect timing. So. It's time for me to kind of pass the baton now on to Natalia, who's going to circle back and talk about those incentives that we talked about on the export side, along with some other very important foreign reporting that needs to happen in the United States.
Yes, thank you, Lisa. I want to talk about a couple export incentives that are available for companies that either export their goods and services outside of the US or have manufacturing done outside of the US for the consumption in other countries. So first one is very important one is a foreign derived intangible income deduction. And this deduction actually became part of the tax law here in 2017 as a result of Tax Cut and Jobs Act. And it was needed to make a US tax system more efficient and competitive and be able to compete with other tax jurisdictions that have much lower tax rates. So the sales that qualify for these deductions actually include tangible and intangible goods, as well as services that could be either manufactured or even purchased for resale or use by foreign person outside of the US. And this deduction is available for US-based as well as foreign companies as long as they have tax liabilities here in the United States. So the calculation of this deduction, and of course its simplified version, would look something like if you take your US income and you multiply it by the percentage of your export income, which let's use 10%. And then that foreign derived income has to be decreased by 10% of qualified business asset investment, which is, again, 10% of your fixed asset cost, basically, that are being used to manufacture or produce this income. So once you get to foreign deferred income, then 35% of that income is going to be actually your deduction that will, as a result, decrease your taxable base and will make your tax rate down from 21% down to almost 13%. So that's a big savings for US companies. Another export tax incentive that I want to briefly discuss is the ICD DISC, which stands for Interest Charge Domestic International Sales Corporation. So basically, a parent company here in the US can set up this separate tax entity, which is basically tax exempt. It's just paper corporation that needs to have its own bank account, needs to file its separate tax return, but it does not have to have any office or employees or provide any services. So, and then the main company can, based on an export sale percentage calculation, can take a commission deduction, which is going to be an ordinary deduction, and this ICD DISC entity going to pick up that deduction as an income. And then that ICD DISC can turn around and pay out all of that income in the form of a qualified dividend. So you get the ordinary rate, ordinary deduction, and you have a qualified dividend. So the tax savings in rate, it's about 13%. This type of entity also could be used by a C corporation, and it just basically eliminate the double second level of taxation for the C corps. To qualify for this type of a deduction, the products have to be manufactured in US and they should have at least 50% US produced content. Then I want to talk about the transfer price and why is it important. So often we have two companies that have operations here in US and then abroad. And if the operations abroad are located in a low low tax jurisdiction. Now we have, low tax and we have high tax here in US. So we have two tax jurisdictions that could be competing, for basically the same revenue. So US usually has not been very aggressive in this, but other tax jurisdictions are usually more aggressive. And it highlights the importance of intercompany transaction and allocating revenues between these two entities. So for the medium-sized companies, usually it's not that involved, and before we get to determine the requirements that we need to complete a full-blown tax price transfer pricing study, we usually try to evaluate the existing documentation and situation to see what prices are being charged, make sure that documentation exists and it's being followed, make sure there is no aggressive pricing arrangements and no pure execution of existing arrangements. So basically, we try to help our clients to stay out of trouble when it comes to transfer pricing, and if they actually need one, then we will help them to conduct it in a most efficient way. Next thing I want to talk about, as you start doing business outside of the US, it adds complexity to your tax compliance here in US, and you have to start doing a lot of disclosures because IRS is trying to collect as much information as possible about the activities and flow of capital and everything that's concerning US businesses inside and outside of the US. So one of the forms that I want to mention is Form 5471, and it's required by US shareholder that owns controlled foreign corporation. And based on a percentage of the ownership, it requires, it can ask for less or more schedules and disclosures. So if you get above, 10%, then you have to fill out a lot of disclosure forms that actually looks like a separate tax return by itself. Then also, if you are investing in a foreign corporation or foreign partnership, every time you transfer cash to those entities, and if it is 100,000 or more within 12 months, you have to fill out those disclosure forms. If your company or your company's executives have a signature authority on a foreign bank account, you have to disclose it as well. Then if you start having like activities in the form of foreign disregarded entities or foreign branches, you have to disclose it on a form as well. So just basically we want to bring up that there is a lot of disclosure required for the foreign operations, and most of it is again just disclosures. There is no tax consequences. However, there is very heavy penalty that comes for not disclosing this information that's required. The minimum penalty for most of the forms that I mentioned, they start at 10,000 and they can, accumulate very fast. For example, a foreign account non-disclosure could be up to 50% of the account balance. So as you can see, it's very expensive. That's all that I have.
Okay, so Natalia, thank you for going through that. Thank you, Lisa. I think these are just some general topics of different things. As we're getting the feedback at the end of this, if there's topics here that you're interested in, let us know. There's some, obviously, a lot of stuff that we touched on here that we could dig into much deeper. So love to get your feedback from the audience so that maybe we can plan some future events here to dig a little bit deeper into these. I think the main takeaway from all of this is, don't jump into this without doing the right planning, and build a team of strong advisors to help get you through the process instead of trying to do it all on your own. There's just too many pitfalls. let's see, I guess we've got a CPE code here, so I'll let you jot that down. And then,
We have one question for Clark Schaefer Hackett. It's how can you assist businesses that are interested in setting up an office in a foreign country and may need some time, some accounting, tax compliance in the foreign jurisdiction?
so,
Sounds tough.
yeah, so, well, I think this really gets to a lot of the elements of the things that we talked about. It's, putting together a regimented business plan, and documenting all of the different steps and considerations that you need to go through during that process. Obviously Clark Schaefer's here to help support with U.S. tax compliance. Natalia talked about all of the different disclosures, some of the tax incentives that are out there, so we can help clients with those things. But again, from a boots on the ground perspective, we typically leverage our international relationships with our AGN association and work hand in hand with the accounting firms in those countries to help plan around the unique tax aspects in each of the different foreign jurisdictions. So that's typically how we would approach it.
Thank you.
Thank you very much.
I have a question from this end. So from your guys' perspective, for a US-based company that's just accessing the international market, is selling in US dollars, would that be something that is recommended on all bases, or would it be, for example, if you're selling into Mexico, would Mexican pesos be something that would you recommend entertaining that for a company that has no presence in Mexico?
Yeah, so just to repeat that question for the folks that are on the line, the question was, if you're a US-based business that's operating internationally, what is the best currency to charge your customers in, US dollars or maybe the local currency? And I guess what I would say is it depends. I think that charging in a local currency can actually create some competitive advantages because it takes that exchange risk away from your customer, and it might make them more likely to do business with you if they've got some comfort that the cost isn't going to fluctuate significantly. So if you're dealing with maybe smaller, less sophisticated customers, that could be a decent strategy. Now the counterpoint to that would be if you're absorbing that risk in the US, you need to have a robust process here to monitor that currency exposure and take the appropriate measures to hedge it. So hopefully that answers your question. So,
yeah.
Yes. So, okay.
Right, thank you.
Yeah.
Thank you. Hey, everyone take a minute to decompress there. We're going to set up for the last presentation. It's the home stretch. Okay, this is Roger Bora, and we are at the U.S. International Trademark and Brand Protection section, the last section today. And this part of the presentation, or my presentation today, is going to take a high-level review of U.S. and international trademark protection. So as you're working with Debbie and these other, and Clark Schaefer Hackett on your taxes and your international partnership, we'll take a look at what it takes to build a good foundation for your trademarks, for your products as you're shipping internationally. Now, I may skip a few points here. There's a lot of information in this slide. We're on limited time, but I did want you to have kind of the full thought process as we walk through these issues. So what I intend to do here is to try to lay down some foundational aspects for U.S. and international trademark protection. And I will say in the materials, the e-materials and the print materials for the folks here today, I do have a best practices trademark guide within those materials. It's soup to nuts. It talks about much of what I'm talking about today, so you can actually take a look at that guide itself. I also have worksheets in my materials, which will walk you through some very basic aspects of where should we file? What should we file? Why are we filing in India, for example? Why do we need to protect in these countries? And so I do have some worksheets in these materials that will kind of walk you through those issues. All right, so the topics today, we're going to start right at the base level, how to select valuable trademarks, because obviously we don't want to select trademarks that are not valuable, and we'll talk about what that means. Trademark clearance, making sure the trademark is available in the US as well as internationally. Take a look at how are trademark rights even created? What do we need to do to even, say we own trademark rights? Talk a high-level view of navigating the US trademark process, registration process, and then the global registration process, and talk about some cost-saving strategies, and I'll hit on a couple of points in China. Let's start with the basics. What is a trademark? It's really anything. Anything that identifies the source of a product or service. It can be colors. It can be Owens Corning pink insulation. It can be blue box for jewelry. It can be sounds, the NBC chimes, any words, anything that would a customer would perceive as indicating the origin of a product or service. And I'll also talk about coming up the spectrum of trademarks, the types of words that we can select to function as our trademarks. So here is the first code, TH74. So trademarks that do not distinguish the source of goods and services is obviously not a valuable trademark, right? Because the purpose of trademark is to indicate where a product or service is coming from. And the example here is if you had a trademark OxyGrow for chemicals for enhancing plant growth, and you decide to select that trademark, what would be the result perhaps if out there was somebody using OxyGrow for grow lights for enhancing plant growth? They're not spelled the same, they look different, but they sound the same, and the products are related. Wouldn't the average consumer reasonably believe that chemicals for enhancing plant growth would originate from the same source of the company that sells grow lights for plant growth? So we have to be thinking about it's not the same mark, it's not the same goods, it's confusingly similar marks for related goods. And so as we're thinking about our US brand launch or the marks we have now that we want to expand internationally, we need to make sure that we're not bumping into somebody in France or Germany where we are sued. We may have to rebrand, and maybe even worse yet, it's a bad reputation. Maybe they develop a bad reputation for chemicals for plant growth that kills the plants, right? And now you're selling grow lights and your sales go down. Why are our sales going down? Well, because someone else has a similar trademark and they've received bad press and people think it's us. So this is what we want to avoid at the very beginning, which will save a lot of time and money. Now, somebody might say that's not how I pronounce my trademark. It's pronounced differently. Well, there's no rule. I mean, the trademark law is settled. It's how any consumer might pronounce the trademark. So we can't get too technical when it comes to this, the sound of a trademark. The spectrum of marks. I have what I call my 4 Ds. When we're thinking about how to select a trademark, is it distinctive? Is it legally protectable? Is it a generic word? Is it just descriptive? Is it distinguishable from the competition? We just talked about that. What's the positioning strategy? Is there a positioning strategy? What are the attributes of the products that customers are looking for in your products or services? I mean, think of Volvo. What's the position of Volvo, right? Safety. So they use positioning strategy in their branding. And this is a book I recommend to clients. You can buy it. I have a stack over here. So anyone here who would like one of these books, they're here for your taking. But you can buy this. This is about a very good a book on how to think through the process of selecting a valuable trademark and what makes sense for your product or service. So what are generic terms? Generic terms are terms we never want to adopt as our trademark because they'll never indicate the source of our goods or services. Think of screen wipe for a computer screen wipe. It's a screen wipe. It's something you wipe your screen with. So, and now what about yo-yo? Yo-yo was a once trademark. It was once trademarked. It's a yo-yo what? Yo-yo what? So when the person who invented this product didn't think about the generic term for the product. So when you're coming up with a never seen before product, you want to also think about what is the generic word for the product. For example, escalator, now generic. It's the escalator, or it was the escalator brand of moving stairs. Well, when the escalator, I guess went off patent, well, what else do you call an escalator? It's an escalator. So the trademark becomes the generic word for the thing. Descriptive terms. These are terms that describe any ingredient, quality, characteristic. It could be the audience, the intended user. It describes something about the product or service. And these words are not immediately protectable. Okay, so you can receive trademark protection for a descriptive term, but it takes time. You have to show acquired distinctiveness, meaning, think of Best Buy for electronics store. Think of TV Guide. These are all descriptive words. Best Buy is a laudatory descriptive word. It's where you'll get your Best Buy. But over time, they acquire secondary meaning, and you can achieve trademark status. But coming out of the gate, it may not be your best bet. Supplemental register. This is where we can register descriptive terms that are capable of trademark status after use. We would prefer to be on the principal. You receive the presumption of validity and ownership. The supplemental is more of a placeholder where you can kind of park your trademark federal level, block anyone else from registering while you try to gain your own trademark status. All right, code 2, TH55. Suggestive mark or terms. These are terms that suggest something about the product or service. I have some examples up there. Florida Tan for suntan lotion obviously suggests what you may receive if you buy this product. Heartwise for, I guess, healthier foods, if you will. Arbitrary terms. These are terms that are common words in everyday language, but there's no connection to the product. So Apple Computer, Wild Horse Beer. Now, these are strong trademarks, some of the strongest, but it's also a bit more difficult to market. So if you're in the marketing group, you're thinking, well, how do I market Camel cigarettes? I now have to educate the customers to what these products are. But if you go too descriptive, now you don't have trademark protection. So I think the sweet spot in my book is usually on the suggestive side, something that suggests something that the customers would like to receive from your product or service, but it's not quite descriptive, but it still says something about what they'll receive. And then there are coined marks, just made up words. These are certainly the strongest marks out there. And so what I recommend a lot of times is when clients want to pick a descriptive term or it's just too descriptive, think of going suggestive, arbitrary, or coined and adding a descriptive tagline, because just describe what the product is or the service is without going too descriptive, because what we'll see in a minute is when you go to international protection, what you thought was suggestive in the United States could actually be descriptive in another country. So you fail to secure registration outside of the US. And so now what? What do we do now? So we'll take a look at that. What are some preliminary considerations when we're looking at trademark selection? Well, I would take a look at the strengths of our product and service. What's the image of the industry or the product or service? What's the values that we'd like to market to our customers? And what might the customers want to receive in the product? This is a good trademark. I find this a great trademark, right? Die Hard for batteries. It suggests something about the product. Close-up toothpaste. This is a positioning strategy. If you are not in the mood for a Coca-Cola, a Pepsi, RC, or any type of cola, well, then maybe you'll think of 7-Up because of their Uncola branding strategy. And strong images. So if we do, as we'll see in a moment, if you select a mark that maybe is descriptive internationally, you would certainly want to have a strong icon, a strong logo that could differentiate your product and service internationally, even if the mark or the words are not that strong. And be careful about growth issues. Don't be too narrow. Don't think you won't expand. So if you may expand in the future and find that you're rebranding because you simply selected a mark that is too narrow. So global considerations. So as we're walking through the selection process, again, what's strong in one company may be descriptive in another. You may find that you're receiving a rejection in the EU, China, because those terms appear to simply describe what the product is, when in our view in the US, it's suggesting something. It's not quite descriptive. And again, if it is descriptive and the horse is out of the barn, consider adding a unique design element to differentiate the branding. Think of language barriers before you launch internationally, right? You want to get some comment from local counsel. And here's a good example of a good global icon. And all of this is covered on my blog. If you go to trademarktitan.com, this is all at the end of my slides. Podcast 4 will touch on all of these things. Trademark clearance. So we've gone through the trademark selection. We've selected a few trademarks. We're thinking of launching these names. What is trademark clearance? Trademark clearance is we want to make sure that the mark is available for use. We're not infringing somebody. It's registrable. It's not generic or descriptive. We want to avoid lawsuits, obviously, right? It's cheaper than defending a lawsuit or a cease and desist letter and rebranding after we've created all of our collateral and we're out and running. We also want to see if we can expand geographically, because if, we'll see in a moment, there are some countries where trademark rights are based on actual use. Where am I using it? If you're using it in the on the East Coast in the US, and you're only conducting business there, you don't have trademark rights in the West. So you could end up running into somebody in the West, even though you started in the East. We want to make sure as you're launching trademarks, you can expand unfettered geographically. And also, what about expanding our product lines? Maybe we're making widgets A and B today, but we have plans to make C and D in 2 years. Let's make sure the trademark is broad enough to protect where we're going. What are some of the misconceptions that I see in my practice? You get a lot of smaller companies. They register their name with the state of Ohio. They have their LLC. They think they have the right to use the name, and that's actually not true, because if that name infringes a third-party trademark already in use, or it infringes another company name that perhaps is registered in California, and they're out there using it consumer-facing, they could actually be causing a likelihood of confusion or actual confusion with customers. Somebody thinks they're buying from the California company, they're now buying from the Ohio company by mistake. So simply receiving a state LLC simply gives you, your official name, but it really does not give you the right to use it. If you secure a US trademark registration, it's the absolute right to use. That's also not true, because there could be a party that was just simply using the mark that did not register the mark, and they may have trademark rights to that name. And so, and also sometimes the trademark office approves trademark filings that should not be approved. And so a third party can still object, cancel a registration, and prevail because the marks are just too similar. I searched the USPTO database and did not find my mark. Well, we have to be thinking about confusingly similar marks, not just the way it's spelled. And another company abandoned its trademark registration, therefore the name is available to use. Well, it may have been an inadvertent abandonment. Maybe they're still using it in commerce and they still have trademark rights. You can't simply just check the trademark office database for the same spelling, and if nothing's there, you're free to go. It's much more complicated than that. So global clearance. Again, protection is less predictable in certain jurisdictions. You could have descriptiveness issues. Clearing in the US does not clear Mexico, Canada, or anywhere else. It's a country by country process. And a guest requests a negative connotation on foreign countries. So when we're looking at the clearance, we're looking at trademarks, thinking about, does my trademark, is it conflicting with somebody else's mark that we've detected? This is basically the test we go through. Would the average consumer reasonably believe that the parties' respective goods and services are of the type that would originate with the same source. Trademark law is about source confusion. It's not confusion as to, I bought running pants and I meant to buy running shoes, right? It's not about I bought the wrong product because of the trademark. It was the same. Was I confused buying the Nike brand of running pants because I thought they were made by the Nike brand of running shoes, the same company. That's what we have to protect when we're looking at trademark infringement. Just a quick run through, how would we search Oxygrow? So we're looking for Oxygrow. If we searched it this way, but only pick up Oxygrow marks as spelled. If we truncate it, we can pick up Oxygrow with a W on the end, because the truncation will pick up anything before, anything after. Would we have found Oxygrow with those two searches? We would not. So if somebody's doing a very basic search and Oxygrow is registered, you file, you get the rejection 10 months later, and you're saying, now what do we do? Well, we may be picking a new name. I would be searching something like this, every vowel permutation in the middle. I'm not going to get into this today, but that's how I'd search it, because that's how an examiner is going to search that trademark. And as my bio shows, I'm a former U.S. Trademark Office attorney, so I used to run these searches for the Trademark Office. Podcast 5 on my blog goes through all of these issues. So how are trademark rights created? We have first to use countries, US, Canada, UK, Australia. These are countries where if we just simply start using our trademark in certain regions, we can secure trademark rights as long as we're not infringing somebody else. And the term is not descriptive or generic. And again, we typically have no rights where we're not using it. We're not selling. We don't have customers unless we're famous, right? We have a well-known, famous brand around the world. Obviously, fame will cover the planet, because if we're that famous, we can pretty much conclude that somebody's using bad faith when they adopted a famous mark to kind of infringe our rights. So in countries where you can create trademark rights just using, right? We have no use where we're not using, but it's still important for trademark registration because we want to preserve our right to expand later. So if we're in the Midwest or we're out east and we're just starting up, or we're launching a product in a remote area just to see if it takes off, if the mark is clear at the point of use, you might as well register it in the US or elsewhere, or at least in the US, because that will preserve your right to expand nationally. So the moment you file, if anyone begins to use after we file, the filing date, even if they use first, we win, because they use after we filed. They were on constructive notice of our trademark rights. So you can kind of put your stake in the ground with that trademark filing. Then there are first to file countries. This is simply, you could be selling and distributing in some of these first to file countries for 3, 4, 5 years. If you haven't filed for trademark protection, you technically don't have any rights. I mean, you need a trademark registration in many countries to have rights. And what you don't want to have happen is your distributor or licensee to register the mark for you, because once they do, it may be difficult to get that mark back. You'll have to battle with them. Session code 3, TH72. Hopefully that's the last one. And it is truly, it can be a race to the office on some of these international countries. And technically it's a race to the office in the US if you both file intent to use applications, because the earliest filing date on an intent to use application could very well be the winning ticket. So US trademark registration does not protect us around the world. So we are going to need to now be thinking about international protection, even though we're registered in the US. Just as Debbie mentioned, I think of a trademark registration as another government business license, right? So if you register your mark in a certain country, they typically give you 10 years. And if you're able to secure it for a couple grand, if you just have limited goods and services, it's $200 a year, right? I mean, that's pretty small potatoes for that, at least that sense of protection. All right, let's look at the US registration process now, because now we're setting up our foundation for using some international filing treaties or mechanisms for international trademark protection. We have minimum filing requirements in the US. If we don't hit these minimum requirements, the office will essentially return the application and we will not receive a priority filing date. And that's important because if we're filing an intent to use application, we don't get the filing date and somebody files the next day and does, and then we file 2 days later, well, because we didn't hit the minimum requirements, we're now second in line. However, we would have been first in line had we filed it correctly. There are different types of trademark applications we can file. We can file use-based applications, intent to use, and I have section 44E there. Use-based applications means that at the moment we file the trademark application, we're using our mark in US commerce. Okay, so and if it's an intent to use, we're planning to use it. We have a bona fide intent to use the mark at some point in the future. But what does use mean? Use does not mean that we have an LLC. That's it. It doesn't mean we have a website that's up and running with the trademark on it. The products are on there. We're offering them for sale, but nothing's been sold. That's not use unless those products have been transported to interstate commerce bearing the mark. Services, we have to be rendering the services. We can't simply be advertising. We're not open for business until we have a customer. We're rendering the services that are affecting interstate commerce. We do not have use of our mark for a use-based application. If it's questionable, file the intent to use. We can circle back later and file the use-based application. And again, the ITU preserves our rights. So if we may not plan to use the mark for a year, but if we've cleared the mark, it looks clean, you file the intent to use, you've put your stake in the ground. If somebody starts using 3 months later, 6 months later, 9 months later, but you don't start using until 2 years later, your application will actually have priority over their actual use. So it's a good way to kind of preserve your ability to build your marketing, build your products. A specimen of use. So in order to have a use-based application, we need to have a good specimen of use. You need to have products that bear the trademark that we're seeking to register. You have to be rendering your services, using the mark in advertising. These links are live. If you have a live, they should be live, but I have a blog post on specimens of use. I have a blog post on point of sale displays, but those 2 items are also in my booklet, my best practices trademark guide that's in the materials. What are some of the trademark traps that I see? The applicant. If we file a US trademark application in the incorrect company name, it voids the application. So some companies will say, well, I want this sister company to be the applicant. Well, but if that sister company is not the company that actually controls the quality of the products and services and the branding, then the application is essentially void. Okay, so we don't want to find out 4 years later when somebody attacks our application that application was filed incorrectly. Scope of goods and services, once we file, we cannot broaden. So make sure right out of the gate, we have all of our goods and services, we know where we're going, we have our business plan in place, and we make sure we adequately protect. Again, dates of use, we don't want to be too early, we don't want to be vulnerable to an attack, because as you'll see in a minute, our international applications we file will be based on these US filings. So if these US filings fail for any reason, all the money we thought we were saving through these international treaties, if you will come down like a house of cards. We'll be starting all over again. So what are some trademark strategies in the US? I typically advise clients black and white drawings only. You know, color marks in my book should not be filed unless the colors themselves are trademarks. So unless you have brown as your color for a delivery company, or blue for your color as a jewelry company, or pink for insulation, you should just file in black and white, because black and white registrations will cover all color permutations. So when marketing decides to change the red color to green or blue goes to yellow, these black and white registrations will continue to protect the updated versions of branding. Standard character marks over design is basically block letter mark. So if it's a word mark, but it's being used in collateral, in cursive writing, or in stylized writing, just file in all block letters, because the block letter registrations will cover you for every stylization of lettering you'd like and any colors you'd like. Stay broad with your goods and services if you can. If you sell sandwiches, don't list 20 sandwiches hoping you got them all, or because when you expand, technically, that 21st sandwich may not be protected. So just say sandwiches, make it easy. I have a blog post on color marks as well. So what happens once we've filed? So we filed our trademark application. If we, if we're in a good spot, I guess it's immediately approved and goes on to publication, or we get an office action or an email or a telephone call from the examiner advising us that we need to do something. Maybe the description of goods needs to be updated a little bit, or maybe we need a disclaimer for a generic term that appears in the trademark, or a descriptive term. Maybe we get an office action, likelihood of confusion. Now we have to go to battle really with the examiner and argue why there is not a likelihood of confusion, and this can add to the costs, adds to the time, adds to heartburn, because if we're going international, now our US trademark filing is now, who knows if it's going to register with this examiner. We need to make sure that we have our clearance in order, or at least anticipate what's likely going to be cited, because then we'll know in advance what our arguments would be. Once and if the mark is accepted, or the application is accepted, it's published for opposition for 30 days. Anybody in the world can object. So that's why, again, going back to the clearance, we want to make sure we've done a pretty good clearance, make sure there's not somebody out there who can oppose. If somebody opposes, we are now essentially in litigation. We want to be careful. We're now the Trademark Trial and Appeal Board in litigation. Registration issuance will then, if nobody opposes, a registration issues for a use-based application. Notice of allowance will issue for intent to use, and then we have a 3 years to file our use-based, our specimen of use. So that's how much time we can secure on an intent to use. I can give you 5 years if you need it. I can play some tricks with the trademark office if I have to. But you'll get at least 3.5 to 4 years. Okay. Oh, the slides are not moving. All right, so once we're registered, you still have to renew the registration at the 5th and 6th year and every 10 years. Oh, push that. All right, let's see if that. Okay, our slides are frozen, so I'm going to move to the paper slides. I think we're good for now. I'm going to expedite my presentation because we may be having some upcoming computer issues. Podcast 6 will give you the registration process. All right, I'm going to go to the paper slides, folks. Okay, I think it's just a little delayed right now. Okay, I think we're back up, great. Okay, let's now look at some global registration strategies. I think that's why a lot of people are here, just hear the international piece. Budget, what's our budget? Where are we filing? What are we filing? What's our filing strategy? As was just mentioned a moment ago, where are we doing business, right? So where do we want to file our trademarks and applications? Where are the majority of our sales? Where are our customers located, distributors, licensees, and certainly where are we manufacturing? And as we look at international filings, we certainly want to take a look at some treaties. Right, for this presentation, I'm talking about the Paris Convention, the Madrid Protocol, EU trademarks, and some national filings. What is the Paris Convention? This is a 6-month priority filing period, meaning that if we file an application in the United States today and you want to file in 6 other countries, we can file in those other countries within 6 months from today, roll out those filings over time, and help string out the costs a little bit so you don't receive one big lump sum of bills for all these international filings. So it's a strategy that we can use to roll out costs. How does this work? So ABC files in the US on January 1st, 2022. XYZ files in Germany on May 1st, 2022. And by the way, XYZ searched the German trademark office and says, wow, the mark's available. No one has it. ABC comes along in June, files for the same mark, same goods, bases it on the January 1st application. Now XYZ is in second place. ABC just used that 6-month priority period to file in another jurisdiction. So this is also why clearance searches are good, but they don't always detect every potential issue. So what is the Madrid Protocol? This is an international application. A lot of people think that you file an international application, we're protected globally. We're done, one application. It's actually a filing mechanism. It's administered by the World Intellectual Property Organization. And again, it's based on your home country trademark filing. So going back to the US filings, we need to have solid foundation. Or as we'll see in a minute, one of the cons to this mechanism is that if the underlying country filings fail, all of these other applications will then fail. So how does it work? So we want to file in India, EU, Japan, and Mexico. So actually, we file the application at the US Patent and Trademark Office. So Thompson Hine, for clients, can file in these countries for our clients through the USPTO filing system. If everything is in order, the USPTO certifies the filing and sends it off to WIPO. WIPO certifies it, hopefully, and then sends our applications off to these countries. So now we are now filed in all of these 4 countries and jurisdictions without having to hire local counsel. We just saved a lot of money just up front alone. Now, if we receive an office action, we will have to hire local counsel at that point. So what are the pros? One application, one registration, one filing fee, one renewal. It avoids the fees of foreign counsel. Over 80% of the global trade is available via this filing mechanism, and we can add new countries at a later date. So once the IR issues, we can now add Spain, or we can add some other countries that are not already covered. What are the cons? Again, the dependency. If the underlying filings fail within the first 5 years, then the whole system fails. We have to then convert these into national filings, file all over again through local counsel, but we can retain the filing date if we file within a few months. What's an EU trademark filing? An EU trademark application covers all EU member countries, now 27 with Brexit. It's one fee, one renewal, automatic extension to all members, new members. What are the cons? It's good to one or good, it's good to all or good to none, meaning that if we want to do business in Spain, France, and Germany, but there's someone in Poland that has a confusingly similar mark, they can object to our EU trademark filing and it will fail. So it has to be, our trademark has to be good to all of the countries or to none. And again, that's why clearance is critical. So what would our filing strategy be for this, this example? These are the countries we want to protect our mark in. We have our US basic filings. Don't forget Paris Convention priority. We can roll these out over 6 months. Madrid countries, the IR countries are listed there. We can file in all of those countries. I minus out China. China has a very short window for response, so I like to use my local counsel instead. So I move that over to my national filings. And so that's how we would set it up. You could file the Madrid now in 2 months. In 3 months, file Argentina, 4 months Panama, 5 months China, roll it out over 6 months and save on those costs. So what would those costs look like? The known costs, not office actions, not third-party objections. National filings, if we went straight through national, you expect about 22,000 right out of the gate. Madrid, 11. So if you had a filing of 60,000 national, using the Madrid protocol, if it makes sense, you have a good foundation, is a good way to save on some of these costs. What about an EU versus these countries? You can file individually, maybe, you know, the known costs are about 7,500. All of the EU, 34. No issues. Let's take a look at China. China is a first to file country. And maybe people here are on the webinar has had issues in China before. I've personally been involved with at least 80 disputes in China, litigation, one case up to the Supreme Court, counterfeiting, raids. If somebody has registered your mark in China, it's likely a pirate. And in many cases, you're better off paying the ransom than fighting, because many times you'll spend a lot more fighting thinking you can win. The laws are better today than they were a few years ago, than they were 6 years ago, but it can still be expensive. So what do? You pay ransom. Maybe you can file a cancellation action for non-use after 3 years of registration. Maybe you can show bad faith. Maybe it was a former distributor or somebody who you've had a relationship with, and you can prove that. Maybe your mark is famous, right? So you can use fame. The registration system is also different. In the US, the Chinese system has a sub-registration system or a subclass system, meaning that instead of just class 9 for any class 9 goods or class 12 for any class 12 goods, there are subclasses within those buckets, and the trademark office will assign certain goods to sub-buckets within class 9. And so when you file in China, the Chinese examiners do not technically think through the likelihood of confusion process. If your product falls in the same sub-bucket as somebody else's product, and it's the same or very similar mark, they will automatically issue a rejection. And also, if you have a class 9 application or registration, somebody can actually file for a class 12 for the same mark and related goods without a citation. And my example in the slides was, let me flip the page, Die Hard battery. So if you have Die Hard brand is registered in class 9 for car batteries, technically that leaves open the window, no pun intended, for somebody to register Die Hard for windshield blades. In the United States, the trademark office would have cited a class 12 windshield blades for Die Hard against a class 9 car batteries for Die Hard, because it's the same mark and the goods are related. In China, because they fall in different sub-buckets, the office may very well just let them go through because they're in different buckets. So when we're thinking about China registration, we also want to be thinking about defensive filings, not just what we're doing, but what might somebody else want to do that could be related to our products. And one example in real life we had was our client sold engine belts for cars and motors. Somebody sought registration for wax to use on engine belts. We could not use their registrations to stop them. We had to use other means. And our client actually recommended you should never use wax on engine belts. So it's one of those things. In China is we have a lot of experience here, a lot of enforcement experience. I have great counsel on the ground that help our clients out. And with that, I think we will go to the last slide. I'm going to recap the COE CPE codes for everybody, and then I'll take any questions that may have come through. So session 1, Debbie's session. We have D as in dog, A as in apple, 09, DA11, DA4, Session 2, TR88, TR91, TR12. Session 3 is TH, as in Thompson Hine, 74, TH55, and TH72. So with that, I'll take any questions.
You have one question. If we have numerous marks to register globally, how do we know which marks to prioritize due to costs?
Yeah, it's a good question. So obviously you want to protect your flagship name. You want to make sure you have your umbrella brand protected for your core products. If you have any core products, top end products, you want to protect those. I typically say slogans are probably last, but usually you just need to prioritize. And if you go through my worksheet in my booklet, it actually works through these particular questions, and you should come out with at least some form of a roadmap for what your next steps could be. So, okay, I have a few more things to say here, and then we can take some more questions. We have a few minutes left for anyone else. First of all, I want to thank Debbie, Lisa, David, and Natalia for presenting today, and for all here in our office and all of those listening online. As mentioned earlier, this is being recorded, and we will send you all slides and the handouts, and I believe also a link to this recording. If you have any questions that we were unable to cover today, reach out to any of us. We're all more than happy to jump on the phone with you, talk to you about these issues. And we want to thank everyone for coming out today and joining us, but we will take more questions if you have any coming in. Any questions in the audience here?
So
Yeah.
there is a company that does a service similar to ours.
Now we're getting into advice. Sure, go ahead.
So just kind of a general question. So they do a service similar to ours,
Yep.
but their name is completely different. Their logo is the same general. Their website is different, but if you type in our company name, not the complete company name, but the original company, initial company name, the name that you hear, you think of when you say our company name, it goes straight to their website. So
Yeah.
From that perspective, they are international, and internationally they're known as our company name. So what would your overall feedback be to that? Is that something that?
Well, we'd have to take a look at a few things. Number one, where are they originating from? What country are they in, right? Trademark rights are country by country specific. So if they're actually shipping products to the US, but you have prior rights in the US, but maybe they have prior rights in other countries, you want to make sure before we send a letter, they don't send a letter back saying, well, you now need to leave the UK, you need to leave this country. So we want to make sure where our global rights are. The names are different. I see two things. Maybe it's a keyword search terms issue where they're using your company name maybe as a keyword. Maybe there's straight up infringement if there's something going on in the Google search results. If the logo is similar, maybe it's not a trademark infringement, but could it be a copyright infringement? Because trademark infringement, you have to have confusion as to the source of the goods. So if you're in the same space, and obviously you could have a trademark issue, but if you weren't, you could have a copyright issue, but not a trademark issue. But these are the things that are kind of going on in my head right now, but we'd have to kind of sit down and look at it. But you've got to think about multi-jurisdiction issues that could come up. Okay. Well, thank you everyone for joining. We'll see you back next time.